Hey there, I'm the MadCatster. Am I glad to see you here? Well, I know it's been a month since my last video. There's a lot been going on, but let me tell you, there's a case going on right now. Mr. Beast, the golden child of YouTube, and Amazon are being sued by a bunch of participants for his Beast games, this big production that he made in conjunction with Amazon Prime. And they're alleging some really horrific stuff. Let me tell you, some of this stuff you are not going to believe. So, you know me. I've got the deets and all the receipts. We're going to dive into it. So, buckle up and let's go. So, I'm here tonight with Cedric, who's being a little rambunctious tonight. Sybil's upstairs sleeping. For those of you who've asked, Sybil's totally fine. There's nothing wrong with her right now. Sybil's getting old. She's an old girl, and she's just gotten to the point where she's kind of just wants to sleep all the time. I promise you for the next video, I'm going to bring her down. Also, stay tuned to the end of the video. We've got a bunch of people to thank for sending stuff from the cat's Amazon wish list. We really appreciate you. But now let's talk about this lawsuit against Mr. Beast. And it's actually been filed as a class action lawsuit, which is basically when there are a bunch of people who have been affected by the same thing or the same set of circumstances, and a lot of times law firms will pull all of these people who are unrelated together and ask the court to certify them as a class and file it as a class action lawsuit so that everybody is represented in one lawsuit instead of them filing a million individual lawsuits. So we're going to talk about what they're alleging, which is pretty horrible, as well as what they want from Mr. Beast and Amazon. Of course, lawsuits, as we talk about all the time, are about money, so they have to show damages, and so damages is what they're seeking in the form of money. And also, I want to just let you know, you're going to see a lot of this is redacted, when you black out stuff. That's not me. I didn't actually redact anything in this particular lawsuit. The stuff that you see redacted is stuff that the attorneys who filed the case with the court redacted themselves. So unfortunately, we have no control over the information that they've chosen to hide. And from what I understand from reading through this, it's because of these agreements that Mr. Beast's company had all of the contestants sign. And in order to avoid breaching those agreements, the attorneys have proactively blacked out a bunch of stuff so that the public record will not show that information. So, of course, the court will see it, but we can't see it. But anyways, there's enough here, believe me, to see exactly what it is they're accusing the defendants of. Today's video, I'm pleased to say, is sponsored by Aura. They've been a great partner to the channel, and it's a very important time to be talking about Aura because you're not going to believe this, but hackers may have stolen the social security numbers, get this, of every single American. Over 2.9 billion records were stolen from National Public Data, which offers personal information to employers, private investigators, staffing agencies, and others doing background checks. And these stolen records include a person's full name, address, date of birth, social security number, and phone number, along with alternate names and birth dates. How frightening is that? The hacker group, get this, have reportedly released this information out onto the internet for free. How is this possible in this day and age when all of these incidents we've heard about continue to happen? If you weren't taking precautions with your personal information that's out there on the internet before this, well, this should be a huge wake-up call because you've never been more vulnerable online than you are right now with this huge breach. Aura monitors your personal data, including your social security number, across billions of data points like the dark web and public court records to detect and alert you to potential identity theft. I'm not too worried about it, as I said, because I use Aura. I've been using them for several months now, and Aura sends me alerts on a regular basis. Whenever they find my name, my phone number, or my social security number on the dark web, I get an alert from them so that I can take precautions to secure my information. They're going to let me know fast anytime anyone tries to use this information to access my credit or my bank accounts. And they also give me up to $5 million in identity theft insurance just in case the worst case scenario should happen. But they also provide a bunch of other great features, and all of this is contained in one app that is really simple to use, and it's really great. I've enjoyed using it. You can go to my link at aura.com/MadCatster, and I'll put that link down below in the description as well. And you get to try it for 14 days free. That should be enough time for Aura to let you know if any of your personal information is exposed and if you're vulnerable. I highly recommend that you do this right now, because not only is national data not going to do anything to help you as a result of this leak, but they're also probably not even going to face any kind of consequences or repercussions for having this happen. I'm not leaving myself vulnerable to data breaches, and I haven't now for several months that I've been using Aura, and you shouldn't either. So go to aura.com/MadCatster and sign up for your 2 weeks free trial. And again, thank you, Aura, for sponsoring this video. So let's take a look. So you see here, it was filed in the Superior Court for Los Angeles. And you can see here the plaintiffs, it just says contestant 1, contestant 2, contestant 3, contestant 4, contestant 5 are the ones who are the primary plaintiffs in this lawsuit. And they are suing Mr. B 2024 LLC, a North Carolina limited liability company, Off One's Base LLC, a North Carolina limited liability company, and Amazon Alternative LLC, a California limited liability company, and Does 1 through 100 inclusive. A lot of times you'll see that where they'll list does, like, you know, as in John Doe, Jane Doe, and they'll put a certain number because they're anticipating potentially naming additional defendants, but they just haven't identified them positively yet. So they're leaving room to come back and amend that caption and add those people specifically by name. And you can see here's what the complaint is for. It's a whole bunch of stuff. Failure to pay minimum wages, liquidated damages for failure to pay minimum wages, failure to pay overtime, inappropriate harassment, failure to prevent harassment, negligent infliction of emotional distress, failure to provide uninterrupted meal breaks, failure to provide uninterrupted rest breaks, failure to pay wages promptly upon termination, failure to provide accurate and itemized wage statements, failure to indemnify for employee expenses and losses in discharging duties, unfair business practices, false advertising, and they're asking for declaratory relief, and they're also requesting a jury trial. So here's the introduction to the lawsuit. Plaintiffs bring this action on behalf of themselves and a proposed class consisting of all individuals who were engaged as purported contestants in the Beast Games content production in, and then they black that out. Defendant production companies and Amazon shamelessly exploited the labor of approximately X number of people who served as contestants on the forthcoming $100 million Mr. Beast Amazon production Beast Games, which Amazon promotes as the world's largest live game show with the biggest single prize in the history of television and streaming. The Beast Games entertainment value arises directly from the physical and emotional labor of the contestants who compete under pressure cooker conditions for life-changing prize money, with one person purportedly to win $5 million in the end. Defendant Mr. B 2024 LLC is a production company believed to be owned in whole or part, directly or indirectly, by James Jimmy Donaldson, the creator and face of the YouTube-originated Mr. Beast brand. Mr. Donaldson, aka Mr. Beast, is a 26-year-old, I can't believe he's only 26 years old, content creator who, on information and belief, has the most YouTube subscribers in the world and is the first YouTube billionaire. The Mr. Beast Entertainment empire produces stunt philanthropy, I like the way they phrase that, which typically features Mr. Beast performing corporate-sponsored, attention-getting philanthropy for publicity. The business model essentially is that Mr. Beast performs giving away some corporate money, whether pallets of cash, cars, or even houses, to strangers or followers, and his corporate sponsors compensate him with even more corporate money. Defendant Amazon Alternative LLC is, on information and belief, the unscripted television division of Amazon Studios, which reportedly was previously run by Mark Burnett. And Mark Burnett, I believe, is also connected to the Survivor reality show at MGM Worldwide Television Group before Amazon Studios acquired the division in the Amazon merger. Amazon Alternative creates content for Amazon's Prime streaming service, which boasts over 200 million paid subscribers. These two commercial giants, Mr. Beast and Amazon, partnered with production company defendant Off One's Base LLC to produce Beast Games, which would be filmed in, and they blacked that out. Mr. Donaldson, who has publicly represented that all Mr. Beast contestants get paid if they compete for just 5 minutes, gushed to his fans online about the bigger than ever scale of the Amazon sponsored Beast games, stating that money was not a constraint and Amazon had given Mr. Donaldson all creative control and the ability to do whatever he wanted. Unfortunately, the supposedly magnanimous Mr. Beast did not want to use the alleged unconstrained resources to provide fair wages or even bare minimum legal working conditions to the contestants, whose labor comprised the core commercial value of Beast games. Instead, defendants employed superior bargaining power to coerce the contestants to sign unconscionable contracts with illegal terms and illusory obligations, and also knowingly mischaracterized the contestants to avoid defendants' employment obligations under California law. So that's a pretty serious allegation. But one thing I will say, before you sign any contract, you should always consult an attorney if there's any doubt in your mind. Because when you sign a contract, presumably it's knowingly. And they're trying to say that they were coerced into signing this. I think that, personally, I think that's a bit of a stretch. And I'm sure there probably was a clause in there that even said, review this with an attorney, because usually these kinds of agreements do. That doesn't excuse anything bad that happened. But I don't think someone sat there with, a gun to their head and said, sign this agreement. Defendants knowingly misclassified the contestants in part to obtain a tax credit for $2,250,523 from the state of Nevada. So apparently they filmed this in Nevada, which defendants on information and belief would not have received if they had disclosed the production's actual labor costs, including the significant labor of the contestants, in the budget they presented to the Nevada Film Commission with their tax credit application. Defendant then induced blank to serve as contestants on their $100 million production based on a false representation that 1,000 people would be competing to win $5 million, announcing only upon the contestants' arrival, blank, reducing the contestants' odds of winning before the competition began. So what I gathered from reading through this is they must have increased the number of contestants, which obviously would have lowered the odds of them winning because now there are more people competing, but I can't tell for sure unless I see the unredacted version. Defendants further relied on the misclassification as a false justification to avoid paying employment taxes and to spare the production the cost of implementing various employment protections required under California law, including minimum wages, overtime, mandatory meal and rest breaks, workers' compensation benefits, itemized wage statements, and timely payment of wages and reimbursements, among other things. The defendant then subjected the contestants to unreasonable, unsafe, and unlawful employment condition. Defendants began Beast Games by blank, where the contestants were held under strict control and surveillance for days on end. So I'm guessing they're talking about the accommodation. They must have checked into accommodations, and after that they were basically watched by the production people. During Beast Games engagement, the on-set production staff maintained the strictest control over the contestants, denying them all privacy and access to the outside world, which I would have thought was probably pretty standard for what they're doing. They didn't. During the Beast Games engagement, the on-site production staff maintained the strictest control over the contestants, denying them all privacy and access to the outside world. The contestants were fed sporadically and sparsely. They were not given adequate access to hygienic products or medical care. The New York Times reported that over a dozen people who participated in the first installment of Beast Games said they had not received adequate food or medical care, and that some competitors had suffered injuries from the physical challenges. The female contestants, particularly and collectively, suffered as a result of defendants' actions. The Beast Games work environment systematically fostered a culture of misogyny and sexism where the production staff did nothing. Female contestants who were also denied, and I don't know, I'm wondering if it has something to do with those monthly cycles, I don't know. Defendants' violations of California law have caused common injuries, in fact, that are redressable and conducive to resolution as a class action. This is where they're going to sort of justify the class action. Where all of the following material facts are common to all contestants. Defendants offer the contestants equivalent compensation for equivalent labor. Defendants misclassified the contestants in a uniform manner. Defendants subjected all of the contestants to the same material working conditions, including a hostile work environment for the female contestants. Defendants have improperly denied or delayed the contestants' overdue wages, penalties, and or reimbursements. So basically, they're justifying the class action, and what they're saying is everybody was operating under the same rules and was treated the same, etc. So basically, they're justifying the class action by saying all of the people who are plaintiffs all have the same complaints, worked under the same conditions, and had the same treatment. The plaintiffs have filed this action using pseudonyms and applying conservative redactions that limit public viewing in a good faith effort to comply with defendants' overbroad confidentiality provisions, which plaintiffs allege are unenforceable, as well as to preserve the confidentiality and privacy interests of the plaintiffs who wish to avoid opprobrium. So basically, they don't want a lot of publicity. And then they talk about venue, which we don't need to talk about. So the next, we're going to jump down to the facts here. The contestants engaged in what appeared to be a thorough application and vetting process for Beast Games. The contestants who were selected and agreed to serve as contestants on the Beast Games 2024 production participated in what at the time appeared to be a thorough application and contestant vetting process. The first step in the application process was to submit, and must have to do with the kind of documentation and stuff they had to submit. Once accepted, the contestants were required to put their lives on hold to provide labor exclusively for defendants in exchange for compensation and a chance to win a $5 million prize on Beast Games. The contestants incurred supposedly reimbursable business-related travel expenses, for which many, including contestant 2 and contestant 3, have not yet been reimbursed. B, the contestant agreements that the contestants enter into with production defendants included blank. And we have no idea what that was. The contestants each entered into a contestant agreement with defendants Mr. B 2024 and Off One's Base, in which the contestants agreed that, and again, we don't know what they redacted out there. The parties to the contestant agreement, including production defendants, also agreed the contestants would be blank. Contestants were employees under California law, but defendants intentionally misclassified them to defendants' economic advantage. Defendants wrongfully and willfully misclassified and on information and belief continued to wrongly misclassify the contestants, although they should be legally classified as employees. And my guess is that what they're redacted out here is that they're considered to be independent contractors, which means they didn't actually work for Mr. B's company, but they were employed for a particular function, or Mr. Beast doesn't want to consider them as employees for employment taxes, benefits purposes, etc. And by classifying them as independent contractors, they would pay them without benefits or any of the other stuff regular employees get, and then they send them a 1099 at the end of the tax year for whatever they got paid. The contestant agreement states on its face the contestants blank, but the arrangement was in fact an employment arrangement whereby defendants Amazon, Off One's Base, and Mr. Beast were the actual employers of the contestant employees. So they're saying they were actually employees during the whole filming of this production. The contestants were not volunteers. The contestants were promised... Oh, that's interesting. Volunteers. The contestants were not volunteers. The contestants were promised and received compensation in exchange for their services. So I don't know whether Mr. Beast called them volunteers in this agreement, which is kind of weird because you're not a volunteer if you get paid. On information and belief, each of the defendants is a for-profit company in the business of making audiovisual programming, including for distribution on the video platform YouTube and Amazon Prime Video, among other platforms. The contestants were promised and received compensation in exchange for their work, I'm guessing, on the Beast Games production. Additionally, Mr. Donaldson made public statements online that he had unconstrained control over Beast Games, and Donaldson had established a pattern and practice of compensating everyone who competes in the Mr. Beast competitions, win or lose, even if they competed for only 5 minutes. The contestants were not working for free for the Beast Games for any humanitarian or any other public service or charitable objective. Defendants hired contestants to work as contestants on a reality competition show. The contestants in reality were the essential labor component of the entire production. Their work on the show was the entertainment product that defendants were marketing and selling for public consumption and profit. And that's true. I mean, obviously, The whole content is the contestants and all the stuff that happens to them and that they do. The contestants were told that if they accepted the opportunity to work for a defendant, they would have to be available for, and it must have been like a time period. And while they were working for defendants, they would not be able to accept any other employment. So that's important because if Mr. Beast is saying that they're independent contractors, and yet he is telling them that they can't accept any other work, that starts to come into the factors that the court's going to consider to determine whether they were employees or independent contractors. We'll talk a little bit more about that as we get into this. Defendants compensated the contestants throughout the course of the Beast Games production with both in-kind compensation as well as cash compensation, with defendants promising blank to every contestant that blank. So they must have been promised something depending on how far they got in the contest, I'm guessing. And when they say in-kind compensation, they mean basically like, food, lodging, etc. is considered compensation even though it's not monetary. Defendants have since requested and plaintiffs have provided blank from the contestants to pay them and to reimburse them for their expenses. Contestants 2 and 3 to date still have not been reimbursed for out-of-pocket expenses they incurred. As a result of the combination of foregoing, the contestants cannot properly be characterized, I'm guessing volunteers or independent contractors. Rather, they were at all relevant times employees who worked at the direction and control of each of the defendants and for these defendants' ultimate profit. So that's two of the other important factors, is whether you are totally independent, which plays into the term independent contractor, or whether the company you're doing the work for controls and directs what you do, when you do it, etc. Because then it starts to move towards the category of being an employee if you're not free to make your own schedule, etc. The contestants had no autonomy. Defendants exercised complete control. Again, this goes to the whole employee versus independent contractor analysis. Defendants exercised total control over the manner, means, and timing of the work performed by the contestants by controlling essentially every aspect of their lives during the production of the show. This included, but is not limited to, requiring blank, controlling blank. So talking about specific things in their lives or aspects of their lives or their ability to do things that was allegedly controlled by Mr. Beast, and we don't know exactly what those things are. When and where defendants required the contestants to be physically present on specific dates and times around the clock at locations dictated, controlled, and supervised by defendants, and which dates and locations blank. Defendants further required plaintiffs dedicate all of their time to the production during the production period, requiring them to miss other work if they had other jobs. And then this whole section is redacted. Access to personal belongings, so something about control of their personal belongings. Restricted movement. Defendants corralled the contestants into tightly controlled blank with accommodations, I'm guessing, where they were actively supervised by production staff around the clock without any privacy. No contact. Defendants exercise total control over the contestants, must be like their communications or communication devices. Control over meals. Defendants controlled when, where, and what the contestants ate, I'm assuming. The limited sustenance that defendants provided afforded an unreasonable and insufficient caloric intake, which collectively and in uniform manner endangered the health and welfare of the contestants during their time blank, I guess, making the show. The contestants had to suffer through blank when defendants allowed contestants to have food. Then it must be something about like the amount and the frequency. So basically what they're alleging is that the defendants, Mr. Beast and Amazon and the other company, were starving these people, is what they're saying. So that's kind of crazy. Control over clothing. Defendants controlled the clothing that the contestants wore. One day the defendants corralled the contestant and must talk about like something they made them wear. So I mean, I kind of don't think is a huge deal, because unless it's like requiring them to wear something skimpy, I don't know. But if they had to wear outfits for particular activities, that might be expected. Control over sleeping arrangements. Defendants controlled where, how, and whether the contestants slept. Whether they slept. Contestants were filed into blank where they slept overnight. Control over medications and recreational substances. Upon their arrival, defendants separated the contestants. They must have like taken away medication, which is kind of weird. That's something I would think they would not want to do, for liability reasons. Exposed to dangerous conditions. Contestants were exposed to dangerous circumstances and conditions as a condition of their employment, even without considering whatever confidential conditions existed behind closed doors while the Beast Games were being filmed. The contestants were subjected to dangerous conditions within the course of their employment. As local news reported, many contestants found it was the poor set conditions rather than the challenges themselves that proved to be the main difficulty. Well, that's saying something. When the conditions is the tough part and not all the, I'm assuming, difficult challenges that they had to go through. Under conditions which they were underfed, overtired, and competing in stressful and exhausting challenges for a cash prize that could change their lives. The danger, moreover, was exacerbated by defendants' seeming failure to conduct background checks. So that's why they made a big deal of that at the beginning. Apparently they were allegedly doing background checks, and something must have happened that somebody didn't get thoroughly vetted who was allowed to compete, is my guess. On information and belief, there was insufficient medical staff to attend to potential and actual injuries during the production. There were several reports of injuries. For example, in an online article, Scott Robin of Vital Vegas reported on July 19, 2024, that in a concerning twist to this story, a source claims Desert Springs Hospital has seen countless patients today coming from the Beast Games due to lack of food and water. That's pretty shocking. Defendants require the contestants to sign an unenforceable adhesion contestant agreement. So they're going to argue that the agreement itself was unenforceable because it was unconscionable probably, and that it was unreasonable, etc. They talk about the agreement, but they've redacted so much that we can't even guess at what they were saying. The contestants performed work that was in the usual course and scope of defendants' businesses. The work that the contestants performed for defendants is not work outside the scope of defendants' core live entertainment content business, as would be the case, for instance, for a service provider providing ancillary production services, such as a food caterer. The usual course and scope of defendants' production business has nothing to do with cooking or serving food. So what they're saying is, calling them independent contractors would be because you were contracting services that you didn't have in-house, basically, and so you need a third party to provide that service for you. So they're saying basically that contestants were performing the basic business, making this content that is the core business of Mr. Beast and these other companies. So this is stuff that they normally did that didn't require outside help, is what they're saying. Here on Information and Belief, the usual course and scope of the Mr. Beast as well as defendant Mr. B 2024's business enterprises is a production of live, non-scripted or semi-scripted entertainment content whose primary focus is on the contestants' reactions to extreme stress as they compete in intense and exhausting challenges to win life-changing money. On Information and Belief, defendants Off One's Base, an Amazon alternative, are also in the business of producing live, non-scripted, or semi-scripted entertainment content. The contestants and their reactions to extreme emotional conditions are the sine qua non of the Beast Games production. Their work is squarely within the usual scope of the defendants' customary business. The contestants are not customarily engaged in an independently established business of the same nature as the work performed for the defendants. The contestant work that the contestants perform for the defendants is not work or services they provide to others. Unlike the catering example, the contestants do not make their living providing contestant services to various customers. Rather, this was labor that contestants provided particularly for defendants. So, in other words, like the caterer, as an outside independent contractor, all they do is cater. So people employ them to come and cater, events and productions and things. Whereas they're saying that the contestants, they're not professional contestants. They're only doing that for this one particular instance, for this production for Mr. Beast. The contestants are, on Information and Belief, people from all over the world who engage in various professions, are unemployed, or are students. They are not engaged in an independent business of the same nature as the work performed for defendants. The contestant work that contestants performed was for defendants and pursuant to defendants' customary business model. The contestant work that contestants performed was necessary to the defendants' Beast Games production, and the work the contestants performed was for defendants' benefit, as the contestants provided the core entertainment value of the production. Defendants misclassified the contestants to avoid their employment obligations under California law and to wrongfully receive unearned tax credits from Nevada. From on or about X date, the contestants worked a non-stop, continuous stretch of employment for defendants during the production. From between certain set of dates, with individuals working non-stop periods of employment around the clock, starting on blank date, reasonably assuming a significant number of the contestants were non-Nevada residents, defendants would likely not meet the requirements that the percentage of Nevada to total qualified expenditures exceeded 60%. So it sounds like in order to get the tax credit, you have to employ people who are Nevada residents, and that 60% of the people working on the production have to be from Nevada. So what Mr. Beast and the other defendants were probably saying was, well, the contestants aren't employees, so we don't count them. But let's look at the production crew. And so 60% or more than 60% of the production crew is from Nevada. Therefore, we're applying for this tax credit. And what the plaintiffs are saying is the contestants were actually employees of Mr. Beast. And if that is the case, then that 60% threshold is not going to be met, because if you factor in the contestants, it brings that percentage down. Moreover, defendants later required the contestants to complete blank, suggesting they intended to write off the contestants' wages as expenses in an attempt to have their cake and eat it too. So, in other words, they're saying they wanted the tax credit and then they want to write off the independent contractor work. Fudging the true labor costs by labeling the contestants, I'm assuming independent contractors or volunteers, which is bizarre, to obtain the state of Nevada tax credit, saving money on employment wages, benefits, and employment taxes by misclassifying the contestants and deducting contestant labor as expenses after the fact. Defendants required the contestants to sign an unconscionable agreement with illegal and unenforceable terms. As a condition of their employment, defendants required each contestant to enter into a contract of adhesion that was drafted by defendants, which plaintiffs in the proposed class were given to sign under expedient circumstances. In other words, they're saying they were rushed, I guess, to sign them. On or about June 6, 2024, on information and belief, the application period for Beast Games opened. Defendants enjoyed superior bargaining power and used it to impose terms and conditions that are unlawful under California law, including the labor code. Defendants demanded, for instance, that something in violation of FEHA, in particular this section of government code. They also required plaintiffs to whatever, which was a violation of another part of the labor code. And then I'm going to skip these because they're so redacted. Again, we can't figure out what they're saying. Defendants failed to provide a safe and helpful. Now this is where we get into the culture, and what they're saying was environment that basically encouraged inappropriate harassment. So listen to this. Defendants failed to provide a safe and helpful place of employment to the particular and collective detriment of the female contestants who suffered inappropriate harassment. Production defendants also failed to provide a safe and helpful place to work in violation of the labor code, as well as government code and sections of that. Production defendants created working conditions that jeopardized the safety of workers, including by not providing sufficient food or drink, taking away their access to, I guess, medication, not having adequate medical staff on site, and not providing reasonable medical care, forcing them not to sleep, and forcing them to participate in games that unreasonably risked physical and mental injury. Now, to that part, I would say that they must have signed some kind of a release, and you need to read the release. I'm not saying that makes it okay for whatever it was that they had to do, because I don't know what they had to do. Whenever you participate in a reality show like this, they always make you sign some kind of a release acknowledging that even up to, the ending of your life could be an outcome. Production defendants additionally created the toxic and hostile work environment for, in particular, the female contestants who suffered, I don't know what, but as well as inappropriate harassment throughout the production, as more fully detailed below. Maybe it was SA is the thing that's blacked out. Harassment throughout the production is more fully detailed below, which was not only noticed but allowed, and even, I'm going to think, condoned by the production defendants. And apparently this was allowed because of marching orders from the top. So they're basically accusing, like, Mr. Beast himself, I'm guessing, and the top brass at Amazon and the other company of allowing this kind of an environment to exist. Purported, now this part is what's particularly disturbing to me, and it comes from a leaked publication from MrBeast's internal operation. So listen to this. Purported How to Succeed in MrBeast Production Handbook states that it's okay for the boys to be childish. And if talent wants to draw a dick on the whiteboard in the video or do something stupid, let them. Really do everything you can to empower the boys. Does he not have any women involved in his organization? When filming, and help them make content. Help them be idiots. A document that appears to be MrBeast's employee handbook, written in the first person from what appears to be Mr. Donaldson's perspective, titled How to Succeed in MrBeast Production. The MrBeast handbook was published on the internet on August 13, 2024 by YouTube creator Rosanna Pansino, who alleges that she received it and confirmed its authenticity with two MrBeast employees. This alleged MrBeast handbook provides insight into the Boys Will Be Boys working conditions that are seemingly promoted by Mr. Donaldson, which, if such MrBeast handbook is indeed distributed to MrBeast production staff, advises employees really do everything you can to empower the boys when filming and help them make content. Help them be idiots, emphasis added. And if talent wants to draw a dick on the whiteboard in the video or do something stupid, let them. Helping the boys make content apparently translated to, and must be some of the outrageous actions that allegedly occurred. The apparent MrBeast ethos of helping the boys be idiots seemed to pave the way for production staff to allow this, probably essay and harassment to go on. And on information and belief, contestant 4's and 5's experiences, as further detailed below, corroborate the reports. While the production staff initially stated whatever this is, contestant 4's and contestant 5's experiences, as further detailed below, corroborate these reports. Upon information and belief, production defendants knew or should have known about this behavior. Additionally, defendants knew or should have known blank because its own employment handbook, as detailed above, laid the groundwork for the collective SH and SH against female employees. So what they're saying is it shouldn't come as a surprise to the defendants because they put out there this handbook that basically says this kind of environment's okay, therefore they shouldn't be surprised that this stuff actually did happen. And then this whole section about whatever happened to contestants 4 and 5 is completely redacted. And then whatever this horrible stuff was, they're saying that by refusing to intervene, the production defendants permitted to exist and fostered a culture and pattern and practice of harassment, including in the form of a hostile work environment where, and then whatever happened. Beast Games created hostile conditions where women were forced to endure the severe embarrassment and unfair disadvantage of, I don't know what all this is. Defendants appeared to take no steps during the course of the production to address the conduct. At all times relevant on information and belief, defendants, management, up to and including senior management and ownership, had actual and or constructive notice that the violence and harassment detailed herein was occurring within the workplace. At all relevant times on information and belief, defendants, management, up to and including senior management and ownership, had actual and or constructive notice that its production staff was aware of, but failed to remedy the violence and harassment detailed herein. Defendants made multiple false statements to contestants in connection with Beast Games prior to the start of the competition. Defendants falsely advertised that the competition would have 1,000 contestants, but I'm guessing there were more, and this cut into the odds of winning. On March 18, 2024, Amazon shared news that MrBeast and Amazon MGM Studios announced the new reality competition series Beast Games in large print text just under a graphic showing Mr. Donaldson amidst a backdrop including the Amazon Prime Video and MrBeast logos. Amazon continued that the new show will premiere on Prime Video and is set to become the biggest reality competition series where 1,000 contestants will compete for a $5 million prize. So, they've got proof that 1,000 contestants is what they say was going to be. I'll be interested to see what it was, whether it was an increase in numbers or whatever the factor was. It actually decreased the odds for all these people. Mr. Donaldson himself also announced the same day on his MrBeast Twitter account that the Beast Games competition that I'm going to be filming the largest game show in history and releasing it on Prime Video. Over 1,000 contestants, $5 million prize, and many other world records. Accordingly, at all relevant times, defendant Amazon Off One's Base and MrBeast held themselves out collectively as the creators, promoters, and producers of the Beast Games, and all did so in order to profit from the endeavor. Obviously. Defendants widely promoted right through the first day of the Beast Games competitions that there would be 1,000 people competing. However, contestants who had traveled blank having blocked off, I'm guessing, amount of time that was required by defendants to compete in Beast Games. Only first found out when the competition started that, and then whatever this change was. This did not sit well with contestants who made their feelings known to the New York Times reporter Kircher, who reported that right from the start things seemed off. Some contestants said they had originally been told the competition would have 1,000 participants. This was also the figure advertised by Prime Video earlier this year. Kircher went on to add that after learning the contestants would be competing against blank, some said they felt they had been misled about their odds of winning. Defendants misrepresented that reasonable meal needs would be met. Beast Games Productions represented the Beast Games rules packet that the blank, whatever the food would be provided to the defendants. Defendants failed to mention, however, that these, if they could be called that, meals, I'm guessing, would be infrequently provided and insufficient in the number of calories in each meal, where plaintiffs allege, by way of example, and then they talk about example, indeed, according to local news reports, multiple Beast Games contestants were taken to the hospital, including for dehydration. Scott Robin of Vital Vegas reported that the local Desert Springs Hospital had seen countless patients coming from Beast Games due to lack of food and water, that the production had allegedly denied food to diabetics, denied water to contestants, and at least 2 individuals had seizures as a result. My God, this is really horrific. In addition to promising contestants defendants would handle blank, defendants also promised Beast Games rules packet that, and we don't know what, in that talk. Okay, we'll skip this. For example, contestant 4 included their assignment, but the production did not until days after. I don't know what that is. Okay, skip to 96. Some contestants opted to blank, but many are still awaiting their promised reimbursement. Must be like settle for whatever they were owed. I don't know. I'm just guessing, but many are still awaiting their promised reimbursement. For example, contestant 2 and 3 have submitted documentation to be reimbursed, but defendants have not yet reimbursed them. The Beast Games production was so void of standards of reasonable care that Mr. Beast allegedly offered to cover the contestants' therapy. That's pretty bad. The foregoing acts by defendants created an environment during Beast Games that was so void of humane standards that defendants ended up volunteering to cover the cost of the contestants' therapy. It was that bad. The combination of all the foregoing created an environment in which the contestants suffered severe emotional distress. We've talked about severe emotional distress before. It's kind of hard to prove, but I don't know, under these circumstances, maybe they will meet the criteria. Defendants apparently aware of the severe distress they caused contestants by their lack of reasonable care in conducting the production, allegedly offered to cover contestants' therapy. Pansino has reported on alleged contestants informing her that defendants knew it was bad because they also offered to provide therapy sessions using their own insurance. So that's not a good look for Mr. Beast and the other defendants, because that does kind of show sort of a tacit acknowledgement that this was not normal what happened to these people. And then we talk about their individual experiences, which have mostly been redacted out, so we're going to have to really skip this. Again, we have to skip all of this because we can't make any sense out of it without the redactions being removed. Contestant 4 understood they would be compensated by defendants for their services. As of the date of filing this complaint, contestant 4 still has not received compensation for their services. And then we'll skip down from the proposed class because we've talked about all this, what they're alleging regarding the wage statements and break penalties, etc. And there's a proposed subclass here. It says for violations of California code, for statutory penalties, declaratory relief, and injunctive relief in the form of ordering defendants to institute workplace reforms and training programs for employees and supervisors to prevent further harassment, including inappropriate harassment, as well as for punitive damages, attorneys' fees and costs, interest, including prejudgment interest, and any other relief as the court may deem fair. Part of the relief that they're asking for is for the court to issue an injunction ordering that the defendants provide this training so that the allegations of what happened doesn't happen again going forward. And then causes of action. I'm just going to read the header. We don't need to go through all the details, but here are the causes of action. Count 1 is failure to pay minimum wage against all defendants. Count 2, liquidated damages for failure to pay minimum wages against all defendants. Count 3, failure to pay overtime wages against all defendants. Count 4, harassment by the proposed subclass against all defendants. The subclass must be the female contestants, I'm guessing. They cite to California statute, and they say that this subsection imposes an ongoing duty on defendants to refrain from harassing an employee on the basis of gender or sex, from creating a hostile work environment, and to prevent discrimination and harassment on the basis of gender and sex. Defendants' harassing conduct was severe or pervasive, was unwelcome by the proposed subclass members, and a reasonable person in their circumstances would have considered the work environment to be hostile or abusive. The proposed subclass members, in fact, did find the unwelcome harassing conduct by defendants to be hostile or abusive to themselves. The foregoing conduct of defendants individually and/or by and through their officers, directors, or managing agents was intended by the defendants to cause injury to the proposed subclass members, or was despicable conduct carried on by the defendants with a willful and conscious disregard of the rights of the proposed subclass members, or subjected the proposed subclass members to cruel and unjust hardship in conscious disregard of their rights, such as to constitute malice, oppression, or fraud under the Civil Code, thereby entitling the proposed subclass to punitive damages in an amount appropriate to punish or make an example of defendants. Plaintiffs additionally request a reasonable award of attorney's fees and costs, including expert witness fees under government code, and injunctive relief as set forth in the prayer below. Count 5, failure to prevent harassment by the proposed subclass against all defendants. Count 6, negligent infliction of emotional distress by the proposed subclass against all defendants. Count 7, failure to provide uninterrupted meal breaks against all defendants. Count 8, failure to provide uninterrupted rest breaks against all defendants. Count 9, failure to provide wages promptly upon termination against all defendants. Count 10, failure to provide accurate and itemized wage statements against all defendants. Count 11, failure to indemnify for employee expenses and losses in discharging duties against all defendants. Count 11, unfair business practices against all defendants. As set forth above, defendants engage in unlawful and unfair business practices, including but not limited to violating the above referenced wage and hour laws, intentionally misclassifying employees, requiring plaintiffs and the proposed class to enter into illegal contracts, and providing false information to the state of Nevada to obtain unearned tax credits. In addition, plaintiffs in the proposed class also allege an unfair competition claim derived from defendants' violation of California Business Professions Code, which prohibits any person in the operation of any contest or sweepstakes from misrepresenting in any manner the odds of winning any prize, and misrepresenting in any manner the rules, terms, or conditions of participation in a contest. Here is described above, defendants misrepresented to prospective contestants that if they were selected and agreed to serve as contestants, they would, among other things, be competing against 1,000 people for a $5 million prize. However, plaintiffs in the proposed class discovered only after they arrived that the contest pool was actually whatever number, not 1,000, which materially reduced plaintiffs and proposed classes' chance of winning the competition. Plaintiffs in proposed class lost money and/or property as a result of defendants' unfair business practices, through which defendants obtained unfair benefits and profits at the expense of plaintiffs in the proposed class, each of whom incurred costs to serve as contestants in the Beast Games and did so under false pretenses. Public injunctive relief is necessary here to prohibit conduct that is injurious to the general public. Mr. Beast has over 300 million followers online and will likely garner more fans after the release of the Beast Games production with Amazon. Millions of people could apply to participate in the next Beast Games, and Mr. B 2024 and Amazon should be required to represent truthfully the conditions of the Beast Games and to adhere to the employment protections required by California law. Accordingly, plaintiffs in the proposed class are entitled to injunctive relief requiring defendants to truthfully represent the conditions of the Beast Games, including the number of contestants, before potential contestants apply to participate, to equitably conduct the Beast Games so that women are not unfairly disadvantaged, and to accurately classify future contestants as employees rather than blank independent contractors. And I don't know whether that's volunteer, which makes no sense, but count 12, false advertising, unfair business practices against defendant Mr. B 2024 and Amazon. Count 13, declaratory relief against all defendants. We're not going to go through that. Now here's a prayer for relief. So here's what they're asking the court to do. Wherefore, plaintiffs individually and on behalf of the proposed class request that the court certify this case as a class action, or in the alternative, certify a class for liability only and for other limited issues pursuant to California Rule of Court. Appoint plaintiffs contestant 1, 2, 3, and 4, and 5 as class representatives. Certify the subclass action on behalf of the subclasses defined above, or in the alternative, certify a subclass for liability only or for other limited purposes. Appoint the law firms, and we don't need to go through that. Order class notice to all class members defined above. That's like, you ever get one of those notices either by email or in the mail, you get a little card saying that, class action has been filed against so-and-so, and if you were bought this or that at this time period, you may be entitled to compensation, and you have to like register your claim. That's what that is, sending notice to all the people who were involved. Order declaratory relief as follows: that the court declare plaintiffs in proposed class were willfully misclassified in violation of the Labor Code and award any penalties for each violation as to each member of them. That the court declare defendants' failure to pay wages to the proposed class for all hours worked violates the code. That the court declare defendants' failure to provide uninterrupted meal breaks is a violation. That the court declare the defendants' failure to provide uninterrupted rest breaks. Court declare that plaintiffs in the proposed class whose employment with defendants have terminated, the defendants have violated the code by willfully failing to pay them. That the code declared defendants' failure to furnish accurate and itemized wage statements is a violation. Basically, the court declared defendants' conduct is a violation of the code. Okay, we don't need to go through all this, but anyways, basically they're asking the court to find that the defendants violated the law in all these different ways. And number 8, preliminarily and permanently enjoin defendants from engaging in the practices herein alleged. Award injunctive relief in the form of ordering defendants to institute workplace reforms and training programs for employees and supervisors to prevent further harassment. Award all wages owed. Order defendants to reimburse plaintiffs. Award plaintiffs in proposed class an hour of additional pay for each uninterrupted meal break that wasn't provided. Award plaintiffs in class an hour of additional pay for each required rest break that was not provided. Award plaintiffs and proposed class penalties for failure to provide itemized work statements. Award waiting time penalties due to plaintiffs in the proposed class. Order restitution to plaintiffs in the proposed class for defendants' unlawful business practices as described herein. Award punitive damages to the proposed subclass, so the people who were harassed, pursuant to the Civil Code. Award attorney's fees and costs pursuant to Civil Code and any other applicable laws, and award interest to the maximum extent allowed by law. And then for such other further relief the court might deem just and proper. So there you have it. So that's pretty serious stuff. So they're saying that MrBeast and Amazon and the production company basically deprived them, it sounds like, of medication, allegedly deprived them of rest breaks, allegedly deprived them of sleep, deprived them of proper nutrition, subjected them to harassment, allegedly. All of these things are alleged, of course, until they're proven. But these are all the allegations. It's pretty shocking. You would think that MrBeast would have, with all his money, would have like a really crack team of lawyers and other professionals, and Amazon as well, so that these kinds of things that they're alleging, if they're true, would not happen. But this is what they're saying happened, so it's pretty horrific. I'm sure it's going to result in changes to any future versions, and who knows, Amazon might decide to just drop the whole thing and cancel any future productions of Beast games based on the outcome of this whole suit. We'll have to wait and see. I'll keep you updated on what's going on. I'd like to know your thoughts down below. Do you find this as shocking as I do? What do you think? Are you surprised? Let me know in the comments below. So I'd like to thank a few people who've sent some stuff from the Amazon wish list. So I want to thank Puppy Nuts, aka John Effin Zoidberg, from Keith, Thomas, and Shannon. I'm guessing it's 3 separate people. It's hard to tell. There's no commas. But anyways, thank you so much, you guys, for sending the collapsible carrier. I really appreciate it. Those collapsible carriers are great because I can fold them up and put them on the closet shelf. So thank you very much for that. And also from the same people, we got a beautiful new cat litter box. And I really appreciate that because periodically I have to replace those because, as you can imagine, with so many cats, we have a bunch of litter boxes, and after a while you kind of have to replace them because smells soak into the plastic. But anyways, thank you so much for that. We really appreciate that. And also, you're our star giver this time around, Puppy Nuts. They sent we got one of those beautiful cat perches for large cats, which we really appreciate. I actually have one that's got to be replaced, so I appreciate having a new one. And then from Meh, and I can't read the rest of this because the ink on Amazon's thing ran out. Thank you for sending us some clumping kitty litter, Meh, queen of, and I can't read the rest of it, but thank you so much for that. And finally, from Ashley M, who sent us a big thing of cat treats. Thank you so much. We go through so many treats in this house. Thank you guys so much. I really appreciate all of you who send stuff from the Amazon wish list. We really appreciate it. We really appreciate your generosity. Thank you so much. I want to, of course, thank all of our channel members who contribute every month towards the cat's care. And, of course, as always, our Patreon patrons whose generous support helps to offset the cat's monthly vet bills. And that, I really appreciate you guys for your continued support in that. You guys are wonderful. The cats and I absolutely love you for that. So there you have it, you guys. There's the Mr. Beast lawsuit. I've got another video that's going to be coming out soon. I know there's been quite a gap between my last video and now, but I promise you I'm going to be making them more frequently now, especially that summer's over and I'm feeling good and everything's good. We're going to get back to our regular schedule. But anyways, in the interim, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.